You're listening to the Cyberwire Network, powered by N2K.
Hello and welcome to Caveat, N2K Cyberwire's privacy, surveillance, law, and policy podcast. I'm Ben Yellen from the University of Maryland Center for Cyber Health and Hazard Strategies. And joining me today is N2K Cyberwire's lead analyst for cybersecurity and policy, Ethan Cook. Hey, Ethan.
Hi, Ben.
On today's show, I delve into a new paper discussing the broader implications of the Supreme Court's recent Chattree decision. Ethan has the story of a U.S. appeals court allowing a lawsuit against the big social media companies to proceed. While this show covers legal topics, and I am a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney.
Maybe that's an urgent email from your CEO, or maybe it's a deepfake targeting your business. Doppel is the AI-native social engineering defense platform fighting back against impersonation and manipulation. As attackers use AI to make their tactics more sophisticated, Doppel uses it to fight back, automatically dismantling cross-channel attacks, building team resilience, and providing agentic email protection. Doppel, outpacing what's next in social engineering. Learn more at doppel.com. That's DOPPEL.com.
Ethan, we're back.
I'm back. We're back.
They are still letting the kids be in charge somehow.
Yeah, Dave's gone. He's yesterday's news. He'll be back next week.
He's yesterday's news. He's old hat. Yeah, no, he'll be back. He's out in a secure, undisclosed location. It's like the Odyssey. Every week, Dave washes up on a new island and confronts.
And then he's running away from it. Always back to us.
That sounds like a great video somebody should make within the N2K Cyberwire universe. On to our stories, though, on better topics. So I've talked a lot about Professor Oren Kerr over the years. You know, he's probably a little creeped out by it at this point, but this is a very good paper, and I really think it's worth discussing. And I was kind of waiting for his take on the Supreme Court's Chattree decision. So if you recall, that decision, which came out earlier this summer, said that the Supreme Court does need a warrant to access location data as part of a geofence warrant. The reasoning is that we have a reasonable expectation of privacy in our cell phones' location services. And the Supreme Court, I think, was relatively muted in how it described its own decision. And that's what's interesting here. They didn't say, we're breaking new ground on the Fourth Amendment. They basically said, and this is in the majority opinion drafted by Justice Kagan, this is just an extension of previous Fourth Amendment case law going back to Carpenter, which was about cell site location information. What Kerr is saying is that this isn't actually a narrow case, that this is not only as important as Carpenter, but potentially more important as Carpenter. That this ruling, if you read it closely, reshapes our Fourth Amendment jurisprudence by introducing new principles that we have never yet considered. And he kind of goes over the reasons why this is such a blockbuster. For one, it throws our previous Fourth Amendment precedents either in sort of a different direction than we had previously understood them, or has kind of put them on the chopping block. And we'll get to some examples of that. And then there's uncertainty for lower courts. How are we going to apply this Chattree decision to a bunch of novel circumstances, which you and I should definitely talk about, particularly on a subject near and dear to our hearts, which is automated license plate readers.
So, bringing it back.
Bringing it back to last week. So I will get there. He basically says there are three possible readings of what the Chattree decision is. And these are kind of three competing theories. And I look at them as sort of concentric circles. The narrowest circle is Chattree as a location privacy case. So basically, in that interpretation, Chattree is about location information. There would be special constitutional protection for records that reveal the whole of a person's movement as they travel through physical space. And this is somewhat of an extension of Carpenter, although the court in Carpenter didn't focus necessarily purely on the fact of Mr. Carpenter sharing his location through historical cell site location information. There were other factors. They talked about the depth and breadth of the data collection and the involuntary nature of the collection itself. But I think one reading of Chattree is that we do have extra established constitutional protection in location information. Which would go against some Supreme Court precedent cases, such as the United States versus Knotts, where they attached a beeper on a car that was driving on public thoroughfares. And the Supreme Court said you don't have a reasonable expectation of privacy vis-a-vis where you're driving because it's public. So that interpretation would introduce a lot of novel questions. What actually counts as a location record? How precise must the location be before it becomes a constitutional issue? That sort of thing. Go out a little bit broader, the second concentric circle would be Chattree as a case about cell phone privacy. And I think this is the interpretation that's most grounded in the text. What Kagan seems to be saying in her majority opinion is that cell phones are special. We all have them. We all have to use them to participate in the joys of modern living.
I was going to say, you can't live in today's world without a cell phone. You can, but it is incredibly difficult.
Yeah, I mean, you try doing it, right? Try to go a day without using your cell phone and see how that works.
Any business, anything like, oh, what's your email? You need to have your email on you 24/7. It's just kind of the nature of these things. Text messaging, everything.
Right. I'm driving around yesterday. The skies start to look a little bit cloudy. Bam, on my cell phone, I get a tornado warning alert. I can take action, right? So it's literally everything. And what this interpretation would hold is that because these smartphones reveal a ton of personal information, the court might be saying that cell phone related records, basically records generated by the normal use of one's cell phone, deserve special constitutional protection. So this would apply to things like location services, not necessarily because they're location services, but because it's records generated based on the fact that you are using a modern smartphone. And that would be the key emphasis there. Then you have the largest concentric circle, which would be a reinterpretation of the so-called third-party doctrine. Basically, Chattree, without explicitly doing so, would establish a new constitutional framework around third-party records. So constitutional protection wouldn't necessarily depend on who possesses the data, which is kind of the previous constitutional regime. If the company possesses the data, you lose your reasonable expectation of privacy, but rather on the nature of the information itself. So location data is yours. It's private information. It can reveal intimate details of your life. And maybe we should reconsider that doctrine entirely. He doesn't choose between these interpretations. This is just sort of to introduce to the audience where Chattree could lead us. And it gets really interesting when you start to apply it to novel scenarios. And that's where I kind of wanted to discuss automated license plate readers. So, yeah. And I promise I'll shut up and give you a...
I love your legalese.
I know.
It's my favorite conversations with you.
I swear I'm almost done. But just looking at these three interpretations through the lens of automated license plate readers, if this is purely a doctrine now on location privacy, then I think those are constitutionally protected records. If we're giving extra constitutional protection to the whole of a person's movement, something like flock cameras, that can capture the whole of a person's movement very easily.
I was going to say, I think if you're going under that interpretation, it's unquestionably so.
Totally.
Personal information.
Totally. Whereas if it's the sort of cell phone privacy concentric circle, then it wouldn't apply because automated license plate readers are not on our cell phones. So if it's the cell phone that merits kind of extra constitutional protection, that wouldn't apply to automated license plate readers. And then it gets even more complicated with corporate held records. Or third-party held records. Who holds that information? Well, Flock Camera does, or any other company that collects automated license plate reader data. It often belongs to police departments. So is this information private? Do you have a right in that information, even though Flock is the one that's been taking the pictures? They've been sending it to their clients, who are local police departments. We don't know. All of this is to say the space for new interpretations of the Fourth Amendment is just completely wide open. And I think this article is getting at that. Like, if you read Chattree closely, we are potentially upending decades worth of Fourth Amendment jurisprudence. And we're going to start to see that play out as cases come down the pike. And I think kind of one by one, as we start to see these cases, we should figure out how are courts interpreting Chattree as kind of a narrow case about location records or a case about data held by third parties. And I will stop there. Ethan, take it away.
I think you hit the nail on the head, which we said this when Chattree was made, right? When this was ruled, that this was going to create a lot of headaches for people and that there was a lot of things that still needed to be resolved. And that kind of happens whenever you upend precedent and rule unexpectedly, right? Like, I think it's fair to say that the Chattree ruling, while I personally like it, was not what was expected and was kind of like a head turner. So I'm not surprised that all these questions are being raised. And I think when you can look at Flock, you can look at other example, like other privacy cases. And I think you're going to find yourself coming back to the same kind of conversation over and over again, which is, well, it depends on how you want to interpret Chattree. And I assume that what's going to happen, like logistically speaking, is that over the next, 3 to 5 years, we're going to have several court cases, which are going to have varying precedents based on their own interpretations. And we're going to find ourselves back in the Supreme Court, and they're going to make another ruling that will maybe clear it up. Maybe is the strong word.
It's really, I mean, that is such a great point, and that's absolutely where I see this going. Because the court in Chattree left all of these questions unanswered, lower courts are just going to be guessing. And when you have a lot of smart judges who are kind of guessing at exactly what Chattree means, they're going to make different guesses from one another. We know that there is no singular correct interpretation of Chattree because the Supreme Court itself didn't give us that singular interpretation, if you read between the lines of their decision. So the upshot of this is things are going to be really confusing for a few years. Every criminal defendant is going to try to put the surveillance that led to their apprehension through the Chattree ringer, saying, the surveillance you used is equivalent to the location collection or the location information collection in Chattree, and here's why. Every prosecutor is going to say, no, it's not. And, they'll come at it from a different perspective. And ultimately, these 9 individuals, or maybe a slightly different set of 9 individuals 3 or 5 years down the line, is going to have to clarify this for us.
Yeah.
It would be nice if they could just clarify it explicitly. Like, if we could just ask them a couple of brief follow-up questions, but that's not how it works.
No, and I think they did that purposely. I think they did the kick the can down the road, and hopefully I'm not on the court when this repops back up, or there's been enough case where I've had enough time to really make a decision on this.
Totally.
I think there is, going into the various outcomes that have been, the 3 pathways of interpretation. I think the 2 most interesting ones to me are the phone argument, as well as the general reinterpretation of what personal data means and what the expectation is. Because those feel like, to me, the most truly, if we have the third party doctrine, the truly upending kind of conversations here. Regarding phone, right? I think, as we said, it's a device that is unavoidable in modern society. Like, I'm sure there's someone in the world, in the US, who does not have a smartphone. Absolutely. But vast majority do. Phone companies want you to have smartphones. So there's a reason they do, because they collect crazy amounts of data off of it. That's why you can get like crazy good deals to buy cheap smartphones that are a couple years old, because they want you to have a smartphone. They collect massive amounts of data off it, and they make the money back. I think reinterpreting the smartphone, opens a door to, well, then why not include smart watches, any smart device, right? Things that we can't escape. These are going to inevitably become more and more. I think it opens, we're opening the door there to just start including other devices, because, I agree the smartphone is probably the most egregious of the device. But as everything gets more interconnected, like if my smartphone connects to my car, does that include my car, right? Does that extend over? Because my car can get my text messages, it can get my emails, it can get my phone calls, it can get my location. That to me seems like something that very quickly connects to well, it's just as interconnected. And by that logic, if a phone is a device that is inevitable or is treated extra, then why isn't my car, which does 90% of the same things, if it's connected to my phone?
That's a great point. It's not even just a car. Like, I take my MacBook Air most places that I go. And that also is extremely revealing. If you were to get a look inside my MacBook Air, you'd get much of the same information you get, including things like historical location information that you would get from my smartphone. So if the interpretation of the case is that smartphones are special, that has a lot of very confusing downstream implications. Like, there are a lot of things that are like smartphones, but aren't smartphones. And so what do we do in those circumstances?
Like, if we said that 10 years ago, I'd be like, all right, that's a fair kind of argument because technology was not where it was today. But I mean, my whole favorite like subculture internet movement is bring back the knobs, where people want, appliances and devices that don't have smart screens built into them, because everyone's kind of like, I don't want to have my toaster be Bluetooth connected to my phone or something like that, right? And I think that the more we just keep expanding and, the Internet of Things keeps growing and becomes more interconnected, if we're going to go the privacy route of the phone is this special, unique device, I don't think that really holds up really anymore. And as we become more interconnected, I think that's just going to hold up even less. I think if you flip that and go to the other end, which is the third party doctrine, which I think out of all the all the outcomes is probably my favorite one. I, for a long time, have personally believed that third parties get a huge breadth of just like whoopsie moments when they expose personal data, mishandle personal data, etc. And the punishment is like, oh, we're sorry. Here's some 2 years of identity monitoring. Sorry that you may have your social security, leaked in 10 years. Our bad. And the punishments are the crackbacks for it are just so minor that I felt for a long time that this needs to be something that's addressed. I mean, you look at social media companies and how they collect data and how they harvest it. There are numerous cases, I don't want to name any companies, of ones where they put their software, they don't even know who they're giving the third party software to, right? And this isn't just like, someone's name, right? Which is already sensitive, but it's how often they post, what they post, where they post, what their birthday is, all this sensitive information that if you told someone, hey, I don't want, hey, would you like to give that up to a random person who's making money for you? Most people would say absolutely not. And I think redefining the third party doctrine, while to your point, is going to create probably out of the three, the most amount of headaches out of all of them, I do think is probably the hardest road to travel, is probably the best road to travel for long-term like privacy security within the US. I don't think that will be the interpretation, because I think that will be too many headaches and no one wants to deal with. But it would be the personal, like, I would love to see that.
It's funny because all of these interpretations are outgrowths of the CATS test, which is about reasonable expectation of privacy. Justice Gorsuch would say, how about we just throw out this entire formulation and make this, whether something is a search or not, dependent on traditional property law, right? It used to be if there was a physical trespass on your property, that would count as a Fourth Amendment search. The literal words in the Constitution are persons, papers, and effects, and houses, right? I think when you talk about something like papers and effects, most courts have interpreted those as existing in the non-physical realm, in the electronic world. So if it's our papers, if it's our data and our effects, and we are giving them temporarily for a limited purpose to a third party, in Justice Gorsuch's formulation, it is still our data and we still have constitutional rights in it. So just putting it out there that like, all of this is trying to pigeonhole modern technology into this reasonable expectation of privacy framework, and we don't have to do that. There are alternatives.
Yeah. And I think that alternative is probably, I think going down that pathway is something that would benefit more than not, right? I as someone who's a privacy guy, that like, I think we often like to bend over backwards with terminology and loopholes and be like, well, it's not technically, blah, 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 whatever, right? And part of me always wants to just come back to this, like, let's just come up for air and like all have a sensible conclusion here, which is we all do not like how much data is collected on us. We don't all like that you can go into any data broker website and like Google your name and it will find you, your parents, your siblings, if you have them, kids, their birthdays, addresses, phone numbers, etc. And you're like, that's kind of creepy, right? And yeah, you can request a deletion, but how many people are actively doing that? That's not something that's like standard. And most people don't even know that you can do that. And we've been, well, technically they're not, blah, 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 and I going through the route of like, it's a personal property, right? It's protected. Would just, I think, clear up so many things and like return it to a normal conversation again, and not have to like layer 40 things on top of it.
I mean, we are path dependent because we live in a common law system on this Supreme Court decision that I and many other scholars think is just kind of, I wouldn't even say fundamentally flawed. It's fundamentally a weird way of looking at Fourth Amendment jurisprudence. And I would love to formulate an alternative. And maybe eventually
they threw it against the wall and seeing what sticks, right?
Yeah. And now they've just kind of been stuck with it for 50 years. And it would be great if, that could merit some reconsideration. Now, right now, that only one justice has that frame of mind. But maybe as
who knows?
Yeah, as time continues to march forward,
in 3 to 5 years, we may have two.
And we may have two. Exactly. Sometimes it takes a lifetime for these things to change. Well, we are going to take a short break to get a word from our sponsors, and then we will hear from Ethan on his story.
AI is making phishing attacks faster, more convincing, and harder for people to spot, and traditional security awareness and phishing training weren't designed for this level of attack. HawksHunt helps security teams prepare employees for the attacks they face every day with personalized phishing training that adapts to each employee and reduces risky behavior over time. For IT and security leaders looking to strengthen their human layer of defense without adding more manual work, visit hawkshunt.com/cyberwire to learn more. That's HOXHUNT.com/cyberwire.
Ethan, what do you got for us?
Yeah, so we're going to stay in the legal world today for everyone, but this one's a little bit different. Instead of talking about privacy expectations, we're going to talk about the courts ruling against social media companies, which I think we can all get behind.
Unless you happen to work for one of these big guys, yeah, I think we kind of like them getting their comeuppance. No offense.
I mean, it's only 2 decades coming, right? Yeah. So the Ninth Circuit Court of Appeals within San Francisco rejected an appeal by both Meta and TikTok earlier this week to overturn a lower court ruling, which would require them to face over 3,000 lawsuits in federal court. These lawsuits are explicitly talking about the way that these social media companies have designed their platforms to create addictive features that trap young users in. This is nothing new. This is something that has obviously been a building conversational point for years, as well as has been in the past 6 months. Major lawsuits have been handed against these companies regarding their design practices. Now, for context, many of these companies have evaded any sort of accountability through Section 230.
The magic of Section 230,
right?
Yeah.
You just wave your magic wand and suddenly you did no wrong. So before we dive into that, I figured it would be a good opportunity for you, Ben, here to kind of just cover what Section 230 is and how these companies have used it to kind of evade any accountability.
Sure. So Section 230 of the Communications Decency Act is a provision that says that these big platforms, these companies are protected from liability for user-generated content. The Communications Decency Act, the full statute itself, was a way to try to reduce the smut that was on the burgeoning internet in the 1990s. But in order for some of the big platforms at the time to agree to a law that was going to crack down on some of the terrible things that were on the early internet, like unregulated pornography. They needed to put this provision in there that shielded these companies from liability for user-generated content. So,
and it makes sense, right?
Right. It's not, and the companies will say this, like, it's not, they are providing rules as to what content can be posted on their site. And they should be able to do that without having this sword of potential liability hanging over them. So they've embraced this 230 shield for a generation now. I know there have been several proposals in Congress to do away with Section 230 and to hold these big tech companies accountable. What's interesting about this lawsuit, as I know you'll explain, is this would be a way to hold the companies accountable without really messing at all with Section 230.
Yeah, I think so. So I'm actually a pro Section 230 fan. I'm not a pro with how it's been used, but I think the concept of, especially when you look at how much data is uploaded to the internet daily, you can't catch it all. And holding anyone accountable to catching everything put in on their platform, especially when it's a social media site, is just unreasonable. You're never going to be able to do it. Creating legal punishments for that is just like, what are they supposed to do? Monitor YouTube's supposed to go through every single video that is uploaded to it and take it down within a set number of hours.
Right. I mean, it would ruin the modern internet because companies would just be like, yeah, we're basically not going to host anything. We're so concerned about liability that unless you have the most anodyne, mild content possible, which would be completely uninteresting to most people, we're not going to allow you to post it.
Exactly. So I think I've always kind of looked at them like, I'm for Section 230. I think it's a reasonable request from my platform on the internet that they can have some sort of protection. I think it's when you take it to how they've interpreted it, which is, oh, you can't come at us with any complaints because we have immunity. It's not our fault that that your child's addicted to the content posted on here. It's because you as a parent couldn't control them. Almost like this victim blaming mentality. I think when these new court cases that have really kind of gained popularity over the past year have not been, it's not about the content. It's about the way they've designed their platforms to purposely keep people on as long as humanly possible. So features such as infinite scroll, where you can just keep going forever. You could keep tapping going through your reels and they will never stop. Things like the recommendation algorithms, which are so finely tuned. I mean, there was an article I read a couple weeks ago that there was a group of researchers who went on to TikTok with new accounts, fresh new accounts, new emails, new everything. And they were able to pretend like they were left or right. And TikTok picked it up in under 5 minutes and was able to provide them content in that echo chamber rapidly. It's scary, right? How fast it can go and how finely tuned it can get information for you.
And it puts people in a I never know how to pronounce this word, an epistemological bubble.
Yeah, I've never heard that word before, so I'm right there with you.
They are only exposed to opinions that they already agree with, and it kind of warps their sense of perspective to the point where, not to get too political here, everybody kind of thinks they're part of some silent majority that would win every election if there were not voter fraud, voter suppression, because they're online, they're surrounded only by like-minded people. They're never seeing opinions from people who think differently.
It's confirmation bias, right? Like, if I'm surrounded by, in my personal life, people who agree with me, because you tend to surround with people who agree with you. And then on the internet, I only see content that people agree with me. And I only watch news sources from places that agree with me. Then everyone agrees with me. Why would anyone disagree with me, right? For years, the conversation has never been really about, or hasn't been successfully been about, what the platforms are designing. It's about, how do we, how do we build better content moderation, et cetera. And I think we're now at this tipping point where trials and lawsuits are about, you have to purposely design platforms and knowingly that they would harm mental health, that they would hurt people on your platform, either addict them to the platform, or expose them to maybe concerning health behaviors in a minor, such as eating disorders or self-harm. And you didn't care because you made your millions. And I think this court opens up, this ruling opens up kind of the floodgates, saying, no, these are all, you can be held accountable. And we've already seen major lawsuits, even before this ruling already come home. New Mexico, like days before, had a massive lawsuit wrap up where they fined Meta for $567 million. And it directly in the judge's statement said they contributed to the youth mental health crisis, and that the funds are going to go straight to a teen mental health fund to help with minors who have been either addicted or are being addicted to these platforms. And I think it's also a reaction to, there have been several cases over the past several months. There's a very famous one from California where a woman sued individually about the harms that social media created. I think she was about 20. So she's like, yeah, over the past decade during my formative minor years, these platforms all contributed to my mental health declining severely. And she was awarded, I think several $100 million from various companies.
Yeah, I mean, when it comes to state lawsuits, and you mentioned that I think 29 states have filed some sort of lawsuit related to the harm of online algorithms. A lot of states are really strapped for revenue. And if there's the prospect of winning or just coming to a settlement with one of these companies, every little bit helps. It's not going to be like a major revenue source for a state, but if you can pay for
nearly $1 billion is pretty good.
It's pretty good. If you can, pay for one mental health program in the state because of a successful lawsuit or a settlement, that's certainly going to provide incentive to do it. And now we have the vehicle, right? This is not a case about someone's content that's posted on the platform. That is still protected by Section 230. This is about decisions that these companies are making themselves as to which information to put in front of you to make you addicted. And as Dave has always said, I mean, this is the 21st century version of the cases against the tobacco companies in the 1990s. Like, yes, we chose to smoke. People used to smoke a lot more than they do now. It was very unpleasant. And, that's ultimately...
It's your personal choice, but when it becomes, you've designed such a product that removes a degree of personal choice because we're so scientifically advanced, we can figure out how humans tick. Is it really a choice anymore?
Exactly. And I think that when we get to the oral argument in this case, I think that's going to be a key argument to the plaintiffs here, that it's a yes, we are contributing to our own algorithm by clicking in the first place on certain reels or liking them. But it's part of a much broader system scientifically engineered to warp our brains. And I think in the long run, we might see real damages from that, damages that courts are willing to recognize in terms of mental health harms, that sort of thing.
Yeah, and I think, as this continues to gain headway, I think a conversational point that has been sort of talked about, but not really, I think it's important, is what are the impacts that this is going to have on social media companies? Like, how is this going to impact platforms? Because right now, the general rulings are either A, yes, you contributed negatively to this person's mental health, you have to pay that individual or, class action group a lot of money as, in damages. But I think a lot of the new ones coming through are from states aren't just about, an individual plaintiff suing. They're more about you as a company harmed our citizens. So not only are you going to pay damages, but I think there's a world where we start seeing punishments or legislation come through as more legal precedent is created, saying you need to remove these addictive features. You cannot have an infinite scroll. You cannot have these recommendation algorithms the way they're designed. While they have already obviously there's been some laws proposed about these things, they haven't ever been passed. I think that's a really important conversational point that it needs to be talked about more, which is how is that going to impact social media companies? How is that going to impact the platforms we engage with, right? TikTok was such a massive deal when that got sold within the US, pretty much entirely because of the algorithm, because the algorithm is so effective. Does that destroy these companies' values almost instantaneously? Because you can collect all the data you want, but if it doesn't matter if you can't have an algorithm that processes it, right, and turns it into value.
Right. And the data, as you say, the data in and of itself is generally not that valuable.
Exactly.
Like, if you were to show somebody a typical reel that exists now, if you were to show that to somebody from 30 years ago, they'd be like, what is this? What am I watching? Like, why is this funny? But it's the propagation of these things that is algorithmic driven that makes us more interested in them as a thing. So it is really, the algorithm itself is really the value, which is why this is just a fascinating story, and certainly a lawsuit that we will be tracking closely here on this podcast.
Yeah, I think the long-term implications of this will have dramatic impacts on what, over the next 5 to 10 years, what is illegal, and what is legally allowed to be designed into social media platforms, and what are the avenues for parents or minors who were impacted by these. What are the legal avenues to get damages back? I mean, I'm from that generation where social media was just emerging and really starting to take off when I was in high school and middle school. And so whether it's peers of mine or, the feelings that I've seen online myself from anecdotally speaking, being like, yeah, I could definitely see a world where this gets out of hand really fast in terms of the lawsuits. And at what point does a company say, yeah, we're losing $2 billion a year from lawsuits in this. This is just not sustainable right now, let alone in 5 years when it continues to grow and grow and grow. So I think it's something to keep an eye on, and I think it could have a massive implication for U.S. tech companies.
Well, I think one of the disappointing aspects of this episode for all of our listeners is that it depends on what happens in the next 3 to 5 years.
As with everything, you can't be wrong if I just keep saying that.
I think it's it's a way to propagate our podcast. You can't cancel us if all of these matters are going to be decided in the future, right?
Exactly. You just come back in 3 years. Keep listening for 3 years. We'll have updates.
We'll still be here. Well, thank you, everybody, and thank you, Ethan. That is Caveat, brought to you by N2K Cyberwire. We would love to know what you think about this podcast. Your feedback ensures we deliver the insights that keep you a step ahead in the rapidly changing world of cybersecurity. If you like the show, please share a rating and review in your favorite podcast app. Please also fill out the survey in the show notes or send an email to caveat@n2k.com. This episode is produced by Liz Stokes. Our executive producer is Jennifer Iben. The show is mixed by Trey Hester. Peter Kilpie is our publisher. I'm Ben Yellen.
And I'm Ethan Cook.
Thanks for listening.